HOA Karen demanded my land at the hearing. Then I took my seat on the county board. Why would an HOA Karen demand someone else's land at a public hearing? And what changed when that same homeowner took his seat on the county board? Hello, everyone, and welcome back to the channel. We are glad to have you here for another story about property, authority, and unexpected turns. Before we begin, please subscribe to the channel and turn on notifications so you never miss our latest stories. Thank you for watching, supporting the channel, and spending your valuable time with us. Your continued support truly means a lot. Before we begin, tell us in the comments, where in the world are you watching from, and what time is it there right now? Now, let's get into the story. That stake is 40 feet inside my property. I said it before the contractor could swing his rubber mallet again, and the sudden silence felt sharper than the morning air. I had been drinking coffee beside my barn when the first dull thump rolled across the pasture. Then another. Then another. The grass was still wet enough to darken my boots, and the smell of damp earth mixed with diesel from a pickup parked beside my eastern fence line. My name is Daniel Mercer. I was 58 years old, and those 18 acres had been in my family long enough that I knew every corner marker, drainage ditch, and old oak along the boundary. So when I saw 3 bright orange survey stakes marching across my pasture where no stakes belonged, I walked straight toward them. Patricia Collins stood beside the contractor holding a rolled map beneath one arm. She was president of the Silver Pines Homeowners Association, the subdivision bordering my eastern property. "Good morning, Daniel," she said, with the careful politeness people use when they have already decided the conversation is over. "We are marking the proposed access corridor on my land. For now." I looked at the nearest stake, 40 feet west of the boundary marker. I knew because the original iron pin was still visible near the fence corner. Who authorized the survey? The association. That was not my question. Patricia unfolded the map across the hood of the contractor's truck. A shaded strip ran from Silver Pines toward the county road, cutting directly across the eastern edge of my acreage. "This corridor was included in the development plan," she said. "It provides emergency access and a landscaped buffer. The county hearing is already scheduled." I studied the map without touching it. The paper looked old. Several parcel lines had handwritten notes beside them. "Is this the recorded plat?" Patricia hesitated just long enough for me to notice. "It is the development map. Those are different things." Her expression tightened. "That strip will belong to the association after the hearing." I looked from her to the orange stake, then back to the map. "Which recorded instrument gives Silver Pines an interest in my land?" The contractor lowered his mallet. Patricia rolled the map closed. "You can make your objections at the hearing. I am asking before you place more markers on private property. We are documenting the proposed corridor. Then document it from your side of the line." For several seconds, all I heard was a meadowlark in the pasture and the faint ticking of the contractor's cooling engine. Patricia finally told him to stop. She walked toward her sport utility vehicle, then turned. "You received the county notice, Daniel. I suggest you read it carefully." I watched them leave before pulling the orange stake from the damp soil. I did not throw it away. I carried it back to my barn and laid it across my workbench. Then I opened my pickup. On the passenger seat was a cream-colored envelope from the county clerk's office. Inside was the public hearing agenda Patricia had mentioned. I read the date, folded the paper along its original crease, and returned it to the envelope. My name appeared on one page. Patricia would eventually notice something else printed several pages earlier. For now, I closed the truck door and looked across the 18 acres she believed a hearing could somehow take from me. Patricia had brought a map. I had a deed. And before this was finished, one of us was going to learn which piece of paper actually moved a property line. The orange stake stayed on my barn workbench overnight, still carrying a dark ring of soil near its pointed end. At 6:30 the next morning, I spread my property records beside it while coffee steamed from an old ceramic mug. My deed was not complicated. 18 acres, transferred to me through my father's estate, with the eastern boundary described by bearings, distances, and monuments that had existed before Silver Pines Estates was ever built. I opened the recorded survey next. The iron pin I had shown Patricia sat exactly where I remembered it. Nothing in either document granted Silver Pines a 40-foot corridor. By 8, I had pulled the subdivision's final recorded plat from my files. Years earlier, when developers first proposed Silver Pines, my father had received copies because our property bordered the project. The final plat showed neighborhood streets, drainage easements, utility corridors, and common areas. What it did not show was an emergency access strip across Mercerland. At 9:17, an email arrived from Patricia. Attached was a proposed permanent easement prepared for my signature. The language would have given the association access across a 40-foot wide section running nearly 600 feet along my eastern acreage. It also authorized landscaping, maintenance vehicles, and emergency use. I read the legal description twice. Then I compared it with my deed. The starting point was wrong. Not slightly wrong. It referenced a subdivision monument east of my actual boundary and treated the proposed corridor as though Silver Pines already possessed some underlying interest there. I replied with 4 sentences. I declined the easement. I requested the recorded instrument establishing the association's claimed property interest. I requested the final recorded plat supporting the corridor. And I requested written authority showing the HOA board had approved Patricia to negotiate for my land. Her answer came 12 minutes later. This is a community safety matter and will proceed through the county process. Again, she answered everything except what I had asked. That afternoon, my daughter Emily stopped by after work. She found me at the barn with the deed, plat, tax map, and orange stake lined up across the bench. That looks serious. It looks organized. She picked up the proposed easement. They want 600 feet, approximately, for free. The document calls it a community contribution. Emily stared at me. That is creative. I pointed to the legal description. Look at the starting monument. She studied it for a moment. That is inside Silver Pines. Exactly. The document was trying to describe access from their subdivision into land they did not own as if the transition between the two were already settled. It was not. Before sunset, another envelope arrived by certified mail. This one came from Gregory Hale, attorney for Silver Pines. His letter described the corridor as essential to community safety and warned that refusing cooperation could complicate the pending county review. I placed his letter beside Patricia's proposed easement. Outside, wind moved through the dry grass, and the old fence wire hummed softly between the posts. Emily looked toward my pickup, where the cream-colored county agenda envelope remained on the passenger seat. Are you going to tell Patricia? Tell her what? Emily gave me a long look. You know exactly what. I folded Gregory's letter and placed it inside a new file. Not yet. Why? I glanced at the recorded plat. Because if she has a valid claim, my position should not defeat it. And if she does not have a valid claim, my position should not be necessary. I wrote 3 words across the folder tab, Silver Pines Corridor. Then I set the orange stake on top. Patricia believed the county hearing would answer whether she could have my land. I was beginning to suspect the answer had already been recorded years before she ever asked the question. By Wednesday morning, Patricia had stopped asking for my cooperation and started describing my refusal as a threat to Silver Pines. I learned that from Helen Ward, a retired teacher who lived near the subdivision entrance and had known my family for years. She called while I was repairing a loose hinge on the barn door. Daniel, did you know the association emailed everyone last night? About the corridor? They called it essential emergency access. They said a neighboring landowner is preventing the community from completing a safety improvement. I tightened the hinge screw and looked across the pasture toward the Silver Pines rooftops. Did they mention that the neighboring landowner owns the land? Helen laughed once. Strangely, no. 20 minutes later, she forwarded the email. Patricia had written it herself. The language was polished, careful, and just vague enough to make residents believe the corridor already existed and I was blocking it. I printed the message and added it to the Silver Pines Corridor folder. At 11, Gregory Hale sent another letter. This one was firmer. He referenced public safety, emergency response efficiency, and the upcoming county hearing. He also attached the same map Patricia had unfolded on the contractor's truck. I enlarged it on my computer. In the lower right corner, beneath faded planning notes, were 2 words that mattered more than everything Gregory had written above them. Preliminary concept. I leaned closer. There was no recorder's stamp, no final plat number, no county certification. I emailed Gregory immediately. Please identify the recording information for the attached map and provide the instrument establishing Silver Pines ownership or easement interest in the proposed corridor. His response arrived 3 hours later. The map reflects the original development intent. Intent, not title, not ownership. not easement. That evening, I attended the monthly Silver Pines meeting because Patricia had placed the corridor on the agenda. The clubhouse smelled of brewed coffee and lemon cleaner. About 30 homeowners filled the folding chairs. Patricia stood beside an easel displaying an enlarged version of the preliminary map. When she saw me near the back wall, her expression sharpened. Mr. Mercer has declined to support a project designed to benefit emergency access for this community, she told the room. Several people turned toward me. I stayed seated. Patricia continued. The county board will have an opportunity to evaluate whether one private interest should obstruct broader community needs. When public comments opened, I walked to the microphone carrying only one sheet of paper. Patricia, has Silver Pines recorded an easement across my property? She shifted behind the table. That is part of the county review. Yes or no? Gregory leaned toward her, but she answered first. The development documents contemplate access. Is the map behind you a final recorded plat? Silence moved through the room differently this time. Michael Turner, the HOA treasurer, turned in his chair to study the easel. Patricia folded her hands. The county can resolve technical questions. Then please preserve every version of that map, every board authorization concerning the corridor, and every communication with the developer or county regarding my property. Gregory looked directly at me for the first time that evening. He understood why I had chosen those words. Outside, Emily was waiting beside my pickup. She really thinks the hearing is going to force you into this. She thinks the map proves more than it does. Emily glanced through the windshield at the cream county envelope on the passenger seat. And she still has not read the whole agenda? Apparently not. I opened the truck door, but before getting in, I looked back through the clubhouse windows. Patricia was still standing beside that enlarged map, pointing confidently at a 40-foot strip across my 18 acres. She had turned a boundary question into a public campaign. That was fine with me. Public claims have one useful feature. Eventually, somebody asks to see the public record. The answer was sitting in a county archive under a layer of dust and a date Patricia apparently never bothered to check. Thursday morning, I drove downtown before the courthouse traffic thickened and parked beside the county records building. The lobby smelled faintly of paper, floor wax, and old heating vents. I requested the final recorded plat for Silver Pines Estates, along with every preliminary development map associated with the subdivision. 20 minutes later, I was seated beneath fluorescent lights with 2 sets of plans spread across a wide table. The preliminary concept looked familiar immediately. There was Patricia's 40-foot corridor, drawn west from the subdivision and straight across the edge of what would remain Mercer property. Then I opened the final recorded plat. The corridor was gone. Not relocated. Not narrowed. Gone. In its place, the subdivision boundary stopped cleanly at my eastern property line. I traced the line with one finger, then checked the recording stamp and date. Final approval had been filed years before Patricia moved into Silver Pines. You found what you were looking for? A voice asked. I looked up and saw Robert Gaines, the county surveyor, carrying a rolled set of plans. I had known Robert professionally for years, but I kept my question simple. I want to confirm I am reading these as a landowner, not assuming anything. He pulled up a chair and compared the documents. This one is conceptual, he said, touching Patricia's map. This is the recorded plat. He tapped the final version. The subdivision ends here. Any recorded access easement crossing the Mercer parcel? Not on this plat. He checked the property index and shook his head. Nothing recorded under the parcel either. That was the distinction Patricia had avoided since the first orange stake entered my pasture. Her map showed what a developer once wanted. The recorded plat showed what the developer actually obtained. Before leaving, I requested copies certified by the county clerk. At home, I placed them side by side on the barn workbench. The orange stake lay between them like a bright dividing line. Emily arrived around 5 and immediately noticed the maps. You found it. I found 2 different stories. I showed her the preliminary concept first. This is what Patricia keeps displaying. Then I slid the final plat beside it. Emily studied both. The corridor disappeared. Before the subdivision was recorded. My phone buzzed. Another email from Patricia. The subject line read County Hearing Preparation. She wrote that Silver Pines intended to present its access request formally and expected me to explain why I opposed a project benefiting neighborhood safety. At the bottom, she added one sentence. The county board will determine the appropriate outcome. Emily read it over my shoulder and looked at me. She really wrote that to you? She did. Daniel, this is becoming ridiculous. No, it is becoming documented. I forwarded Patricia's message to my private attorney and requested one additional item from Silver Pines. Every communication concerning the preliminary map and any decision to remove the corridor before final plat approval. The following afternoon, Michael Turner called. His voice was cautious. Daniel, I probably should not discuss board communications, but I can tell you something. Patricia was warned that the map was preliminary. By whom? That is something the records should answer. I thanked him and ended the call. Outside, late sunlight stretched across all 18 acres, reaching from the barn to the eastern fence without interruption. I picked up the orange stake and rolled it between my palms. Patricia had planted it 40 feet inside my property because an old drawing showed a line she wanted to believe was real. At the hearing, she planned to make that line official. What she still did not understand was that the county had already answered that question years ago, in ink, with a recording stamp she could not argue away. The hearing was still 4 days away when Patricia decided to make the dispute public one more time. Silver Pines held a special meeting Monday evening, and by the time I arrived, nearly every folding chair in the clubhouse was occupied. The air smelled of coffee and warm printer toner, and Patricia had mounted the preliminary concept map on an easel beside the board table. Gregory Hale sat nearby with 2 thick binders. I took a seat near the back and listened. Patricia described the corridor as a necessary community improvement, then pointed directly at the 40-foot strip drawn across my property. Mr. Mercer has been given several opportunities to cooperate, she said. The county board will now determine whether his private interests should outweigh the safety needs of this community. A few residents turned toward me. I said nothing. Michael Turner, sitting 2 seats from Patricia, looked considerably less comfortable. When public comment opened, I walked to the microphone. Has the association located a recorded easement across my parcel? Patricia leaned back. That question will be addressed Thursday. Has the association located a final recorded plat showing the corridor? Gregory glanced at her. Patricia answered, We have development documents establishing the intended access. That was not my question. The room became quiet. I placed a certified copy of the final plat on the table. Please include this in the association record. Patricia barely looked at it. You can present whatever documents you want at the hearing. I intend to. She gave me a thin smile. Then the county can decide. I returned to my seat. 10 minutes later, Patricia made the statement Emily would repeat to me twice on the drive home. Mr. Mercer can explain to the county board why 18 acres belonging to one person should interfere with a project benefiting more than 100 homes. Emily waited until we reached my barn before speaking. She really believes you are going to stand at the public microphone and plead your case to the board. I unlocked the door and switched on the overhead lights. The orange survey stake still rested on my workbench beside the certified plat. That is where I will speak regarding my property. You know what I mean. She pointed toward my pickup. The cream-colored county agenda envelope remained on the passenger seat. Why have you still not told her? I took the agenda from the truck and carried it inside. Because my chair does not move a property line. Emily folded her arms. No, but Patricia might stop acting like she owns yours if she knew who she was lecturing. Then she would be responding to a title instead of the record. I opened the agenda. The Silver Pines matter appeared under land use hearings. Several pages earlier was the board roster. My name was printed there with the others. Daniel Mercer, County Supervisor. I had served the district for 6 years. Silver Pines fell within it. Patricia had emailed me county documents, quoted county procedure, and repeatedly threatened to put me before a board without apparently reading the page identifying who sat on it. Wednesday afternoon, Gregory submitted the association's presentation packet. The preliminary map was included again. The final recorded plat was not. Neither was any recorded easement. I added both omissions to my notes. Then I prepared a separate written disclosure stating that I owned the property directly affected by the application and would not participate in discussion or voting. That document mattered more to me than Patricia's surprise ever could. Thursday morning, I dressed before sunrise, placed the certified deed and plat inside my leather folder, and drove toward the county building through low gray fog. Patricia believed she had arranged a hearing where I would finally answer to the county board. She was right about one thing. I would be there. She was simply expecting me to enter through the wrong side of the room. The hearing room was already half full when I arrived, and Patricia had positioned herself in the front row where she could see every seat on the dais. Gregory sat beside her with two binders and a rolled presentation map leaning against his chair. Behind them were Silver Pines residents I recognized from Monday night. The room carried the familiar smell of coffee, paper, and polished wood. 5 minutes before the scheduled start, I entered through the side door used by county officials. Susan Whitaker, the county clerk, looked up from her desk. "Good morning, Supervisor Mercer." "Good morning, Susan." Patricia heard her. I knew because her head turned immediately. I walked past the public microphone and through the railing separating the audience from the board area. Patricia stared at me as though I had misunderstood where I belonged. Then I reached the empty chair beneath my nameplate. Daniel Mercer, County Supervisor. I placed my leather folder on the desk and took my seat. Gregory saw the nameplate first. His expression changed almost instantly. Patricia looked from him to me, then back to the brass plate. Her lips parted, but nothing came out. For weeks, she had told residents that I would answer to the county board. Now I was sitting on it. The chair called the meeting to order, and we worked through 2 routine agenda items before reaching the Silver Pines application. I pressed my microphone button before county staff began. "Chairman, I need to make a disclosure." The room settled. I own the 18-acre parcel directly affected by this application. Because I have a personal property interest in the matter, I am recusing myself from all discussion, deliberation, and voting. I handed Susan my written disclosure. I will participate only as the affected property owner during the portion available for public testimony. Then I stood, walked back through the railing, and took a chair on the public side. Patricia watched every step. For a moment, some of her confidence returned. Perhaps she thought my recusal solved her problem. Gregory leaned close and whispered to her while county planning staff prepared the display screen. When Patricia's presentation began, she spoke carefully about emergency access, neighborhood safety, and the original development plan. Gregory then displayed the map I had seen beside my pasture. The 40-foot corridor appeared in bold color. This access was contemplated during development of Silver Pines, he explained. One of my fellow supervisors asked the obvious question. "Is that the final recorded plat?" Gregory paused. "It reflects the original development concept." That was not the question. I almost smiled. I had heard those words somewhere before. County planning staff took over. Robert Gaines approached the screen carrying a certified document. For clarity, this is the preliminary concept map submitted during early planning. He replaced Patricia's image with another map. And this is the final recorded plat. The 40-foot corridor disappeared. A murmur moved through the audience. Robert enlarged the eastern subdivision boundary. "The final plat terminates here. County land records show no recorded easement extending into the Mercer parcel." Patricia turned toward Gregory. He was already searching through his binder. Another supervisor asked, "Then what property interest does the association currently hold in the proposed corridor?" Gregory looked at Patricia before answering. "We may need to clarify that point." Susan placed the chain of title into the record. 18 acres. Mercer ownership. No transfer to Silver Pines. No permanent access easement. No recorded corridor. Patricia had spent weeks preparing for the moment when county authority would force me to justify keeping my own land. Instead, county staff had spent less than 10 minutes establishing the question she should have answered before the first orange stake ever touched my pasture. And sitting in the audience after voluntarily leaving my own seat, I watched her realize that knowing who I was had never been the real problem. Not knowing what she owned was. Patricia recovered quickly enough to ask for the microphone, but the confidence in her voice had changed. "The association understands that the corridor was not formally recorded," she said. "But the original development intent remains relevant because this access serves a legitimate community need." One of the supervisors leaned forward. "Need and ownership are separate questions, Ms. Collins. What authority are you asking the county to exercise over land your association does not own?" Patricia looked toward Gregory. He stood and tried a narrower argument, suggesting the county could support the proposed access arrangement as part of a broader safety review. County counsel answered before the discussion wandered further. "The county may evaluate an application properly before it, but this board cannot manufacture a private property interest that does not exist in the recorded land records." That sentence changed the room. Patricia had spent weeks presenting the hearing as if it were the final step in acquiring my 40-foot strip. Now everyone understood that the hearing could not substitute for a deed, an easement, or my voluntary agreement. Gregory requested a short recess. During the break, I remained near the back wall while Silver Pines residents gathered in small groups. Emily slipped into the chair beside me. You knew this would happen. I knew what the plat showed. I meant Patricia seeing your nameplate. I looked toward the dais. My chair remained empty because my recusal continued. That part does not decide anything. Across the room, Patricia was speaking rapidly to Gregory. Michael Turner approached them carrying his phone. I could not hear the conversation, but Gregory's expression changed when Michael showed him something on the screen. 5 minutes later, Michael walked toward me. Daniel, there is an email the board needs to produce. Then produce it through the proper process. I sent it to Patricia 6 months ago when she first brought up the corridor. What did it say? He lowered his voice. That the map was preliminary. I checked the county records myself. I told her there was no recorded corridor and that Silver Pines had no property interest in your parcel. I felt no satisfaction. Only confirmation. Does Gregory have it? He does now. When the hearing resumed, Gregory asked permission to supplement the record. He disclosed that new information had been brought to his attention concerning internal HOA communications and requested additional time before pursuing the application. A supervisor asked whether that information affected the association's claim of an existing corridor. Gregory chose his words carefully. Potentially, yes. Patricia stared straight ahead. County staff then summarized the documentary record. The preliminary concept showed a proposed corridor. The final recorded plat did not. The Mercer deed contained no transfer. The property index contained no easement, and the association had presented no instrument granting it ownership or access rights. I was called to the public microphone only after that summary. I carried my certified deed and placed it on the lectern. My position is simple. I support responsible emergency planning. I do not support describing privately owned land as though it already belongs to someone else. If Silver Pines wants to propose an easement, it may ask, but a proposal is not ownership, and a preliminary line on an old map is not a recorded right. I returned to my seat. No title, no speech about my office, no special treatment, just the deed. By the time the board postponed action pending clarification of the association's legal basis, Patricia's large presentation map was still standing beside the screen. The 40-foot corridor remained drawn across my land in bright color. But now everyone in the room knew exactly what that line represented. Not authority, not ownership, just something Patricia wanted badly enough to mistake intention for fact. By Friday afternoon, the 40-foot corridor was no longer Patricia's biggest problem. Gregory Hale sent a formal notice to the county stating that Silver Pines needed time to review newly identified association records before deciding whether to continue its application. Less than an hour later, Michael Turner forwarded the same records to the rest of the HOA board. He copied me because several messages specifically discussed my property. I was standing at the barn workbench when the email arrived. The orange survey stake was still there beside my certified deed, its dried mud now flaking onto the wood. I opened Michael's attachment and found an email dated 6 months earlier. His message to Patricia was direct. He had searched the county records, located the final recorded plat, and found no recorded easement across the Mercer parcel. He had even warned that the preliminary concept map did not establish a property interest. Patricia's reply was only 3 sentences. She believed the original development plan gave the association sufficient grounds to pursue the corridor. She intended to seek county support, and she did not want the issue delayed by what she called technical objections. I read that phrase twice. Technical objections. My deed had become a technical objection. The final plat had become a technical objection. The absence of an easement had become a technical objection. By evening, Silver Pines announced an emergency board meeting. I attended because my property was listed on the agenda. The clubhouse felt different this time. Nobody had placed Patricia's enlarged map on the easel. Michael sat with a stack of printed emails in front of him. Gregory joined by speakerphone. Patricia opened the meeting by saying the association had acted in good faith based on its understanding of the development documents. Michael immediately asked, "Were you aware before the contractor entered Mr. Mercer's property that the final plat did not contain the corridor?" Patricia paused. I was aware there were differences between the documents. Were you aware there was no recorded easement? Another pause. I understood that the county process could resolve the access issue. Gregory's voice came through the speaker. For the record, my office was not provided with Michael's earlier email before the hearing packet was prepared. The room went completely still. Several residents who had previously supported Patricia began looking at one another. Michael held up another document. Did the board authorize a contractor to place markers 40 feet inside the Mercer parcel? Patricia said the work was preliminary planning. That is not what I asked, Michael replied. I recognized the sentence immediately. This time I did smile. By the end of the meeting, the board voted to suspend further spending on the corridor, request an independent review of Patricia's authority to initiate the project, and instruct Gregory to prepare withdrawal documents unless a valid property interest could be produced. Nobody produced one. 3 business days later, the county clerk received Silver Pine's written withdrawal. Susan emailed me a copy because I remained recused from every county action connected to the matter. I read it at my kitchen table while morning light moved across the page. The application was finished, but the association's internal review was not. Silver Pine's residents requested records showing how much money had been spent on legal letters, surveying, and hearing preparation. The numbers were not enormous, but they were large enough to make people ask why any money had been spent before ownership was verified. That evening, I walked the eastern boundary with Emily. The original iron pin sat exactly where it always had. 40 feet west of it, the small hole from Patricia's orange stake was already disappearing beneath new grass. Emily looked across the pasture. All of this because she trusted the wrong map. I shook my head. No, the wrong map was corrected months ago. I looked toward the Silver Pines clubhouse in the distance. This happened because she was shown the right one and decided authority could make the difference disappear. 2 weeks later, the contractor returned to my property for a very different reason. I heard his pickup before I saw it, tires crunching slowly along the gravel shoulder beside the eastern fence. The morning smelled like cut grass and warm soil, almost exactly like the day this started. He stepped out carrying a clipboard instead of a map. Mr. Mercer, he said, Silver Pines asked us to remove the remaining markers and close the survey work order. I appreciate you letting me know. He walked the boundary with me, checking each location against his notes. Most of the temporary markers had already been removed, but one orange stake remained near the far end of the pasture. I recognized it immediately. He pulled it from the ground, wiped the dirt from the pointed end, and handed it to me. Looks like this one belongs to you now. I carried it back toward the barn. That afternoon, Michael called with the result of the association's internal review. Patricia had been removed as HOA president by a board vote. Silver Pines also adopted a new policy requiring documented board approval and verification of recorded property rights before association money could be spent on projects involving land outside the subdivision. Gregory's legal work on the corridor was closed. The association formally confirmed in writing that it claimed no ownership interest or existing easement across my 18 acres. I filed that letter beside my deed. Patricia never apologized to me, and I never asked her to. About a month later, I saw her at a county meeting. She sat several rows back in the public seating while I entered through the side door and took my place on the dais. Our eyes met for perhaps 1 second. There was no argument, no dramatic confrontation, and no need for either one. The public record had already said everything that mattered. When the meeting ended, I drove home beneath a clear evening sky. The pasture grass had grown over every small hole left by those survey stakes. At the barn, I opened the passenger door of my pickup and found the cream-colored county agenda envelope still tucked inside the side pocket. I carried it to the workbench and placed it beside the last orange stake. One had represented the authority Patricia believed she possessed. The other had contained the position she never bothered to notice I held. Yet neither one had decided the outcome. My seat on the county board had surprised her, but I had stepped away from that seat the moment my own property came before it. That mattered to me. If I had used public office to protect private land, Patricia could have claimed the system was simply choosing one powerful person over another. Instead, I let the document speak. The final recorded plat spoke. The chain of title spoke. Michael's email spoke. And the absence of any easement spoke louder than all the presentations Patricia had made. I looked through the open barn door toward 18 uninterrupted acres glowing gold in the late sunlight. Patricia had believed the most powerful thing I owned was a seat on the county board. She was wrong. It was 18 acres, one recorded deed, and the patience to make her prove every word she had put on paper. Justice did not arrive with shouting or threats. It arrived quietly, one document at a time, until there was nowhere left for a false claim to stand.